let's talk about the constitutions. Why am I here? Why am I doing this? Well, because way back in the, remember many of you were active in the Tea Party when the Tea Party really got going in 2009, 2010. And before I became your Secretary of State, after the 2010 election, I was a law professor at UMKC for 15 years. I started in 1996. I finished in 2011 when I had to resign to take over the position of Secretary of State. And so that was 15 years, and I had a 2-year hiatus working for the Bush Justice Department as counsel to Attorney General John Ashcroft, and that's when I was there during 9/11. So anyway, my main course that I taught as a law professor was constitutional law. I taught some immigration law, legislation, legal history, and some other stuff. But well, that pretty much sums it up. Those are the main courses I taught. But the con law was my bread and butter, and was my passion as a law professor. So anyway, back to the Tea Party. So I was finished. I was in my last year teaching at the law school, hoping that I would become Secretary of State. And several people said, "Hey, Kris, you're a constitutional law professor. Can you do some sort of presentation on the Constitution?" And I said, "Well," and I said, "What do you mean, like what kind of presentation?" "Oh, I don't know, like 2 hours or something." And I said, "But this is a 2-semester subject. It's 2-semester courses at law school. It's a ton of material." And anyway, I thought about it. I said, "Well, okay, let me try." So I condensed it down to about 2 hours. And during the Tea Party phase, I did like a 2-hour top speech on the Constitution. But I thought that was a little bit long. And I think people's questions are maybe more helpful too. So I've condensed it down even further to about a 1-hour crash course on the Constitution. So I'm going to be talking fast. We're going to cover a lot of ground. Hopefully you'll find it interesting, because the Constitution is really interesting, and the history of what's been done to our Constitution is really interesting. Tragic at times, triumphant at times. But there's just so much to learn, and I want to try to impart as much information as I can, and then take your questions. So forgive me if I speak fast, but I want to get through this all, and I want us all to get out of here relatively quickly, or we don't want to drag on forever, and I want to keep it interesting. But let me tell you something else that I learned as a law professor. So I would be most of my students came in straight out of college, and so they just finished a 4-year degree, and they were coming into law school at age 22, 23, and I was always amazed at how little familiarity they had with the Constitution. They hadn't been taught about the Constitution in any detail during high school, and they hadn't taken, unless they took constitutional law courses in college, they learned nothing about the Constitution during their 4 years in college. And so they would come in, and it was just amazing to me. So these are people who've made it into law school. They've done well enough in college to make it through the admission process into law school, but they still haven't learned anything about the Constitution. And I'm afraid that the situation has gotten worse, not better. It just seems that our high schools are not doing, in my opinion, an adequate job teaching people about the history of the Constitution, the meaning of the Constitution, and just the story of the Constitution. So here's your crash course. We're going to hit on a number of topics, and we're just hitting a few. So the Constitution has more than 50 different subjects are covered in our Constitution. And so we're not going to hit them all. I'm going to hit 3 subjects, but I'm going to start with some general principles. And who knows? I've got the longer version. We could hit about 6 subjects, but I think 3 is just about right. And these are ones that you'll know a little bit about, and in some cases you know a lot about. So first we're going to talk about general principles of the Constitution and of constitutional law. Then we're going to talk, I'm going to do this faster. Then we're going to talk about 3 topics. Then the first topic is the commerce power. The second topic is the Establishment Clause of the First Amendment. And then the third topic is the Second Amendment. And each of them illustrates a transformation of the Constitution by activist judges. And each of them ends with a glimmer of hope. And when I say transformation, I mean that the Constitution was changed from its original understanding to its original meaning to something very radically different. And then there's been, in recent years, a turning of the ship back, hopefully, toward the original understanding, but there's a long way to go in all three areas. Okay, so before we begin, general principles. Okay, so the United States of America, you might have learned this back in school. People talk about the United States of America being the first in the world to be this or that. Were we the first democracy in the world? Are we even a democracy? No, we're not a democracy because the technical definition of a democracy is government by the people through direct vote. But even if that's what we were, we wouldn't be the first one. The ancient Greeks were a true democracy for a brief period. And Switzerland, the various cantons of Switzerland, some were voting directly on issues as early as the 1200s. And by the 1500s, almost all the cantons of Switzerland were doing this. So they have much more experience as a democracy, but we're not one anyway. Although some of the states have very strong cultural popular initiatives and referendums. But we're not a democracy. We are, of course, a republic. Were we the first republic? No. England was a republic long before us. Republic is a representational system of government where you have members of a parliament or a congress who represent their constituents and vote on behalf and are elected by their constituents. So no, we weren't the first republic either. Oh, so we didn't really do anything new? What did we add? Why did people say America's so great in terms of the systems of government? What we were the first at was we were the first constitutional republic where a written constitution confined government, where it defined and confined government. That had never happened before. This idea that you could, with words on a paper, enforce and keep government restrained. And so it's so important. It was such a strange concept. Now the U.S. Constitution wasn't the first because the states had the 13 states at the time had already written and ratified their state constitutions. So the Constitution of 1787 that we're going to be talking about, the U.S. Constitution, is not the first one we had in America. The states were already experimenting with this concept of defining the powers of government with a written constitution. So where did it come from? Well, there was an early progenitor to constitutions in the Magna Carta, but the Magna Carta wasn't really a constitution. It was a list of rights that the king decided to grant to the people of England. It wasn't something that the people of England held against the king. It was him deigning to give a gift to the people. And the Declaration of Independence, though, was a hint at what was to come, because the Declaration of Independence made clear that things like rights did not come from government. This was the most revolutionary statement in the Declaration of Independence. Was the statement at the beginning. Does it have both? Yes, it does. Was the statement right at the beginning? Well, we all know it. All men are endowed by their Creator with certain inalienable rights. Among these, the rights to life, liberty, and the pursuit of happiness. Endowed by their Creator. That was a direct challenge to the Magna Carta, which was given by the king. Men are given by the king certain rights, and they're not inalienable. He can take them right back. And so the notion that rights come from God immediately puts government in a subservient, the federal government in a subservient position. And they were, of course, experimenting under the Articles of Confederation with a central government. But now the question was, what was this government going to be like under the Constitution that they were drafting in Philadelphia in the hot summer of 1787? And so where do we begin? The first part would be the concept of enumerated powers. So when they came together in Philadelphia, one thing that they all shared in common was a desire to take the state model of a constitution limiting government and apply it to this new federal government. And these were states that were the sovereign holders of power. So imagine each of us in groups of three. We would meet together and we would say, we each represent, let's imagine that Kansas is not settled, and we each represent a little county in Kansas, and the counties have been holding power for many, many years, and we're gonna create a new state government. Each of us is representing our county, or each of us is representing where all sovereignty resides. That's probably a bad analogy, but the point is that all of the sovereignty, all of the power resided in the states. The states had won the War of Independence it was these United States, and they used the plural. They didn't use the United States. For most of our country, at least through the Civil War, people referred to these United States. It was a government of multiple states together. So these 13 states, which were sovereign and largely independent of one another, came together and said, okay, we're going to create a central government, but we are going to do it as a government of enumerated powers, which means listed powers. The only powers that the federal government has are those that are listed in this Constitution. If it's not on the list, it doesn't exist. Kind of like the Johnny Cochran clause of, right? If it doesn't fit, you must have quit. If it's not on the list, it doesn't exist. And so this was a defining concept of the Constitution. If it's not here, it doesn't exist. And if you turn to Article 1, Section 8, which is on page 6 and 7. So it's right here, Article 1, Section 8. You can find pretty much all of the powers of Congress right here on these 2 pages. That's it. That's a pretty short list. And if you look at it, they're very specific things. To provide for the punishment of counterfeiting the securities and current coin of the United States, to establish post offices, to promote the progress of science, basically through patents, to constitute tribunals inferior to the Supreme Court, to define and punish piracies and felonies committed on the high seas. These are really specific little things, and most of them are pretty little, too. And so this is a specific list of the only things Congress could do. And there's a couple of other sprinkled out throughout the Constitution. But this is the main list right here. And so, and that was in contrast to the states. Now the states are sovereign holders of power. They're not enumerated powers governments. They are unenumerated powers governments. And the states can do, they possess what's called residual powers. All that resides, the residuum that is left in the states after they give this tiny little bit to the federal government. And another word for it in the law is police powers. The states hold police powers. Now, it has nothing to do with black and white cars with sirens. Police powers means it's a legal term to describe the right of the state government to pass laws to protect the health, safety, welfare, and morality of the people. So the state of Kansas can define a constitution any way it wants. And if it wants to say the legislature can legislate for the welfare of the people of Kansas, it can. Or the Constitution can limit how the state legislature acts. But the point is, the state legislature of Kansas can, unless confined by the Kansas Constitution, they can regulate anything under the sun, unless it's something that was given to the federal government in this list of enumerated powers. And that's why the 10th Amendment is framed the way it was. And that's why most of the founding fathers, James Madison included, said, well, you know, because some of the states said we need something like this 10th Amendment. And they said, well, it's already obvious. The 10th Amendment is just a statement of the obvious because it's a government of enumerated powers. But the argument the Anti-Federalists made, the people who wanted wanted a Bill of Rights and wanted the 10th Amendment made, they said, well, yeah, we know that's what you think, but we want it written down. And so the 10th Amendment just puts the doctrine of enumerated powers into writing, and of course says that all powers not enumerated in this Constitution reside with the states and with the people therein. It's just a way of stating the doctrine of enumerated powers. But actually the founding fathers thought, when they wrote it, they said, well, that's obvious. That's why we're listing the powers, and why, how else could it be? But thank goodness we do have the 10th Amendment. And in my longer version of this lecture, I do a whole separate section on 10th Amendment cases. But okay, so we have a country of enumerated powers as opposed to unenumerated powers. The other point you have to know about the Constitution is what it does and what it doesn't do. So does the Constitution say this person cannot do these things and this person has the power to do these things to other people? In other words, does it regulate what individuals can do? It doesn't. No, it really doesn't at all. That's what garden variety state laws do and local ordinances do. They govern whether you can trespass on your neighbor's property, whether you can steal from your neighbor. All of that is garden variety statutes. That's not constitutional law. Does the Constitution give power to the states? No, not really. You could argue there's a provision that says that the states can petition the calling forth of the military. There are some things the states can petition, but no, it doesn't really give any new power to the states. The states already held the power. They were giving a little bit to the federal government. But what the Constitution does do is it creates this federal government and then builds a cage around it. And so the best metaphor is a cage. The Constitution is a cage in which you put the beast. And the beast is the Leviathan, as Thomas Hobbes wrote in the 1600s. The government is a leviathan. It is a powerful, hungry beast, and it needs to be put in a cage. And the Founding Fathers understood this, and so that's why the Constitution is written about the things you can do and the things you can't do in the government. And it's so important. Now, the Constitution, by the way, was not a sure thing to be ratified by the people of the United States. So it was drafted in the summer and fall of 1787. It was sent out to the states for ratification, and a lot of states were saying, nah, we don't like it. One of the states actually put it to a popular vote. Anyone want to guess which state that was? Anyone know which state that was? Not Massachusetts, no. It was the feisty one.
Virginia.
Not Virginia. Rhode Island. Rhode Island was the thorn in everyone's side. But Rhode Island actually put it to a popular vote, the Constitution of the United States. And what happened? It failed. It failed big time. I should have brought the numbers, but it was basically it was like a 4-1 vote against the Constitution. They thought that it was still too much power given to the federal government, and it looked doubtful whether New York was going to ratify, and it looked doubtful, certainly doubtful, whether Massachusetts was going to ratify, because you are right, Massachusetts was reluctant, and that's what led to the Massachusetts Compromise, where the anti-federalists in Massachusetts said, we don't want this Constitution, it doesn't have a Bill of Rights. And then the Federalist defenders of the Constitution said, okay, if we promise to draft a Bill of Rights the moment as soon as this new Congress comes into existence and is sworn in, will you say yes and ratify it? And they said, okay, fine. We'll ratify it if you promise to, and with our ratification message, we will send a list of suggested bills in the Bill of Rights. And so some of the ratification messages from the later states included what they wanted in the Bill of Rights. And then James Madison, in the first Congress in 1789, he had this giant list of, here's a big list from Massachusetts, here's a list from Virginia, and he had to sift through this list, and then I once counted them all up, it was like 150 different suggestions to come up with the first 10 amendments to the Constitution. And of course, the 10th Amendment isn't really a list of part of the Bill of Rights in that sense, and the 9th Amendment doesn't say anything specific about any specific rights. And so it's really, he condensed it all into the first 8 amendments, which is really interesting. I thought so anyway. Okay, so there's states that are reluctant. Rhode Island is especially reluctant. New York may not go. If New York says no, so the whole thing's going to fall up. And if Virginia says no, the whole thing's going to fall through. It is not going to be ratified. So they engage in a promotional campaign. And the promotional campaign was called the Federalist Papers. The Federalist Papers were not written as a handy little book like you might buy today at the bookstore. The Federalist Papers were a bunch of op-eds written in the newspapers. These were persuasive editorials written under the pseudonym Publius by the Founding Fathers, James Madison, Alexander Hamilton, and John Jay. And so they wrote these papers during 1788 to try to persuade people, and they were answering arguments. People were making arguments, and there were other editorials written by the Anti-Federalists, and they wrote under the name Cato. And that was the thing to do back then. You picked a Roman name and you wrote under this pseudonym. I should try that sometime. Anyway, that's what they did. So the Federalist Papers are written, and James Madison is immediately getting blowback on the. People are saying this is too big. They're saying that this little list on pages 7 and 8. They're saying this little list is way too big. That's too much power, right there. Too much power for Congress. And so James Madison says. In Federalist 45, written on January 26, 1788, he says, quote, the powers delegated by the proposed Constitution to the federal government are few and defined, but those which are to remain in the state governments are numerous and indefinite. The powers reserved to the several states will extend to all of the objects, which in the ordinary course of affairs concern the lives, liberties, and properties of the people, end quote. And he goes on to say in this same paragraph, he says, and what the federal government's going to do is mainly going to be relating to war, tariffs, and foreign relations. That's what the federal government's going to be concerned with. But all the stuff in your daily lives, that's state government. So this is James Madison, the founder, the main author of the Constitution, saying the federal government does not concern itself with your daily life. Is that what we have today? No, not at all. But that is what the Founding Fathers sold to the states, and he wasn't trying to trick anyone. That is what James Madison believed. And if James Madison were to come back to life and were to stand with us here today or to take a tour around the United States and learn what's going on, he would be horrified. because the federal government is so much, it hasn't broken out of the cage, but the cage has been redefined. So the little cage that they created is now a giant cage. And the federal government, the beast within the cage, has grown so big. There's no question in my mind that that Madison would say that. In fact, I was asked at actually this is, by the way, the 4th Commonwealth 101 class we've done this year. We've done one in Wichita, one in Gardner, one in Salina, and now here. And I was asked in Salina, is it 5th? What's the
Russell, he did Russell today
Oh, Russell,
too.
that's right, 5th. I was asked at the one in Salina, it was a great question. If you could go back in time, and regarding the United States and do something to change something, what would you do? And so I said, well, if I could go back in time, anytime I'd go back and talk to Jesus Christ, because that would be. But if it's about the United States, I would go back and I would talk to James Madison, and I would say, listen, I'm from the future, but I got to tell you, you wrote this in really general terms, and there are judges who are going to twist your words way out of recognition. You've got to write this in much more specific terms, and you've got to write prohibitions that are very clear, you know, because they imagined, it was a much more, I don't know why. I mean, he wrote, James Madison explained that, you know, it's a constitution, and the early Supreme Court justices said, well, the Constitution has to be written in general terms. You can't get too specific in a constitution. But he didn't realize how Congress would push and push and push and change and push against the limits of the cage. And so if I could go back in time, I would tell him, okay, everything you wrote is, all of the provisions, what they create is great, but you have to use more specific language because Congress is going to try, and executives are going to try to stretch what you have done. Anyway, but I can't go back in time. So we are going to have to try to change the course of this nation, which is part of the reason why we're here. I mean, and the way you change things is you learn what's gone wrong, learn where we're off course, and learn where we're on course, and we inform ourselves and then inform our elected representatives and hopefully move in the right direction. Okay, so general principles, done. Let's talk about the commerce power. Okay, so Article Section 1, among the list, is about a third of the way down on page 6. The Congress shall have the power, and then ... to regulate commerce with foreign nations and among the several states and with the Indian tribes. Okay, so really the only operative words are, Congress shall have the power to regulate commerce among the several states. Okay, that sounds, I don't know, that sounds reasonable. And it was reasonable. In the early commerce power cases, it was clear that what they were, that the Supreme Court reviewed, and in the discussions about the commerce power by the Founding Fathers, what they were talking about was regulating trade between the states. Because remember, these states are like quasi-independent countries before this Constitution is written. And so they have different standards, different weights and measures, different rules for what you can do when you come in up the river into that state. And so they were doing things like regulating rivers, regulating the coasting trade. The coasting trade is where a ship would sail from port to port to port along the Atlantic coast. And there were foreign ships doing this, there were domestic ships doing this. And they wanted to establish licenses to who was allowed to engage in this trade. And they wanted to establish rules for pilots. Pilots were riverboat captains. They were called pilots. And to go up the Hudson River, to go up the Mississippi River, to go up any of the rivers, you had to have qualifications to be a pilot. You had to have a license to be permitted to land in the city's docks. And so that's what they were talking about. Congress shall have the power to establish coasting licenses, pilot rules, harbor rules. That makes sense because it's trade between the states. And we want to have a uniform rules of how so it's the channels of commerce and the instrumentalities of commerce. Those are the words that the Supreme Court would use in later cases. And that was what they were talking about. Channels and instrumentalities of commerce. Sure, Congress should be able to do that. And if we jump back in time 100 years, and we were here in Emporia in the year 1920, James Madison's view of the Constitution would be pretty much in effect. In 1920, most Americans would have felt that most of the regulations that they deal with on a day-to-day basis come from the state. Any regulations governing what licenses you have to have in your trade, any laws that you have to follow would be state laws. There'd be local laws too. But it was all coming from the state. There was not much federal regulation of your daily life. The feds were not regulating your food. They were not regulating your carriage or your car if you were lucky to have one in that time. They were not regulating any aspect of your life with any significance. Federal crimes, there were not that many federal crimes yet at that time. And so we did have the antitrust laws. The Sherman Antitrust Act was one of the first big federal statutes, which came at the end of the 1800s. But beyond that, there wasn't a whole lot of federal regulation of your daily life. But that would change with the election of Franklin Delano Roosevelt and the Democrat Congresses in 1932 and 36, after the Great Depression, or in the middle of, after the Great Depression started, and in the middle of the Great Depression, and the New Deal. And so you know that history, I hope. So Roosevelt then starts commissioning, well, Congress, at Roosevelt's request, starts creating all these federal agencies to do things the federal government had never done before. To start regulating prices, to start regulating industries, to start regulating products. And this was absolutely new, novel, and the question was, how can you do this? Where on this list do you find the ability to regulate the price of anything? It's not on there. Where do you find the ability to regulate how something is built or constructed? It's not on there. So this was a big question, and this alphabet soup of agencies was challenged in court again and again and again. And the US Supreme Court, to their credit, in the first half of the 1930s, struck them down. The Roosevelt administration was losing. No, you can't do that, can't do that. And so the New Deal was, in terms of the expansion of federal power, was not gaining steam in the first half of the 1930s. And that's when, in 1937, Franklin Delano Roosevelt does what? He threatens to pack the court. So the court had 9 justices. He promotes the court packing plan. He actually introduces it in a fireside chat in March of 1937. And I should have brought the chat along, but the words he used, he's like, oh, the justification was, well, these justices are getting old. There's a lot of work for the court to do. They need help. We need more justices for every judge who's over, I think it was the age 70. And basically his plan was for 6 more justices, which would have been conveniently enough to establish a governing majority for him on the Supreme Court of the United States. And the court packing plan was introduced in Congress, was getting hearings, and 2 of the justices on the Supreme Court got nervous, and they switched. They backed down and they changed their votes in the case of Jones and Laughlin Steel Company. And those 2 switched, and that was called by lawyers the switch in time that saved 9. A playoff of the stitch in time saves 9. And so the 2 justices switched, and they said, okay, the commerce power isn't just the channels and instrumentalities of Congress. They agreed with the Roosevelt Justice Department that the commerce power could also be regulating things that affect commerce. The way they framed it was substantially affect commerce, but that word substantially eventually came to be emptied of meaning, as I'll explain in a moment. So suddenly, wait a minute, you're regulating rivers, you're regulating, by that point, railroads, you're regulating, by that point, airplanes, which are traveling from state to state. Okay, we get that, but now you're going to regulate anything that affects commerce? Prices, food, products? How? Where are the limits? And it became very clear that if you open up that floodgate, there really weren't many limits, because as we saw, the Roosevelt plan, the federal government began to grow and grow and grow, and these agencies started issuing regulations, and they started setting prices, and they started doing all kinds of things the federal government had never done before. And now they're being okayed, and they're still being challenged in court, but now the Supreme Court is saying okay. And then a few of the justices that had been holding the line die, and so in addition to the 2 that switched, now you have Roosevelt putting his people in the court, and they're saying okay, and now you've got all these precedents, and it hits its peak in 1942 in the case of Wickard versus Filburn. It was the AAA, the Agricultural Adjustment Act, which allowed this federal agency, this federal board, to set prices and on agricultural commodities, crops, and to set limits on how much you could grow, because they were trying to keep prices high for farmers. And so one farmer, Mr. Filburn, challenges it because he's given a quota of wheat that he can grow, but he says, okay, fine, I won't grow any more wheat than my quota for the marketplace, but oh, by the way, I have these extra 2 acres here, and on these 2 acres, I'm going to grow some wheat for my family. This will be wheat that we don't put in commerce. We are going to grind it. We are going to use it to make flour, and we're going to eat it ourselves. This is for my family, not for commerce. Obviously, I can do that. You can't do it for myself and for my family. And guess what? The federal government says, no. You're going over your quota by growing that extra wheat. and you can't do that. You're in violation of the regulations of the Agricultural Adjustment Act. It goes all the way to the Supreme Court. And the Justice Department lawyers say, that substantially affects commerce. If you allow 1,000 people like Farmer Filburn to take a few extra acres or to grow an extra bit of wheat and not buy it on the market, then imagine that's a whole bunch of wheat that otherwise would be on the market. If you have to include those extra 2 acres of wheat. It wasn't 2 acres, but whatever the amount was, you have to include that extra wheat under the quota, because if you allow people to do stuff outside of the quota, that will change the total amount of wheat traded, and that will affect the price. If you multiply Farmer Filburn times 1,000. Well, wait a minute. If you can take any little tiny effect and multiply it times 1,000 or 10,000 or 100,000 to say, there, see, we affected commerce. Well, then everything affects commerce. And the court ruled in favor of the government and said, yeah, you can do that. Farmer Filburn, you lose. The federal government has the power to tell you that you can't even grow a little bit of extra wheat for your family. That has an effect on commerce. And so that was in my opinion, one of the worst decisions the Supreme Court ever issued. And you haven't heard of that one because, well, nobody teaches that stuff anymore. But Wickard v. Filburn then was this precedent that then guided what the Supreme Court did for 60 years. And it's still technically a valid precedent. They haven't officially overturned it, but thank goodness things have changed. So for the next 60 years, every single federal law that is passed under the commerce power is upheld. Now you think about that. Everything affects commerce. If the federal government says all pen ink should be black because green ink and blue ink is hard to read, I don't know, whatever their reason, they could do that because you know what? If you only had black ink available on the market, it would probably affect the number of pens that were purchased. And if it affects the number of pens that were purchased, that affects commerce. I mean, everything affects commerce. And so the federal government's regulating everything under the sun. And we start regulating the FDA, all these new agencies are created, and it's post-1937 that the United States Republic changes away from James Madison's version to this version where the federal government is this giant monster that regulates every aspect of our lives. In 1995, there was a glimmer of hope, and for the first time, the Supreme Court struck down a law as being too far under the commerce power. It was the case of United States versus Lopez, and it concerned the Gun-Free School Zones Act, or the Gun-Free Schools Act of 1991 or 92. Remember that during the first Bush administration? That was the law that said you can't bring a gun within so many feet of a school. And anyway, a case out of Texas, this guy Lopez, high school student, brings a handgun to school. He doesn't shoot anybody, he doesn't commit a crime with it, he just brings it to school, either to show it to his friends or to give it to somebody, I don't know. He brings it to school, they don't know it, but they find it in his locker. And he's charged, he's arrested and charged under the Gun-Free Schools Act because he's brought a gun within the prohibited range within the school. And the case goes all the way to the Supreme Court. And Lopez's lawyer says, look, he wasn't bringing it to sell, he never sold the gun, he never purchased the gun, he never moved it across the state line. There was no commerce here. He just brought the gun within a forbidden area. That has nothing to do with commerce. And the Justice Department lawyers under President George W. Bush, they said, and they're defending this law. Republicans are defending this overreach of Congress too. The lawyers say, but if the students know that Lopez has a gun in his locker, then they will be afraid, or some of them will be nervous. And if the students are nervous during math class, they won't be able to concentrate as well. And if they don't concentrate as well, they won't learn their math as well. And if they don't learn their math as well, when they graduate, they won't be as smart or as well educated. And if they go out into the world not being as well educated, they won't be as productive. And so the amount of commerce that they generate will be smaller. That was the argument of the United States Department of Justice. And thank goodness, Justice Rehnquist writes this opinion. And this opinion says, no, that is not a substantial effect on commerce. Chief Justice Rehnquist wrote the opinion in 95. And he says, you cannot heap inference upon inference upon inference to come up with an effect on commerce. And so it was this breath of fresh air. Finally, the court says there's a line somewhere that Congress cannot cross. And the court strikes down that provision of the Gun-Free Schools Act. The rest of the act is still in effect. But that part, as applied to him, and that's under those circumstances, was not enough. And then the Congress would later make some amendments. But I remember it vividly, because in 1995, I was in my final year of law school at Yale, and the professors were gloomy and, what's going on? Everybody hears about this news. The Supreme Court has struck down an act of Congress that's not being under the Commerce power. And, conservatives like me were smiling, oh, this is great. And there's oh, no, they're writing op-eds in the New York Times. Oh, they can't do this. But this was like a shockwave that in the legal world was just like the huge ripples were rebounding all across the country. They've done it. They've struck down something as beyond the Commerce power because people just thought the Commerce power was a dead letter as a limit. So now fast forward. So there were a couple of other cases where the Supreme Court said things did not. The Violence Against Women Act had a provision that was struck down. The rest of the act stood, but that provision was struck down. And then jump forward now to the Obamacare case. And in the Obamacare case, you remember, Obamacare was challenged, and many of us were a little bit upset at Chief Justice Roberts for joining the activists on the court and sustaining Obamacare. But do you remember that the main Obamacare provision was argued on two different grounds? The first ground that the Justice Department under Obama argued was, of course we can do this. We're regulating interstate commerce. It's right here in the Constitution. How are you regulating interstate commerce? Well, we are taking someone who doesn't want to buy insurance and we're forcing him to buy insurance. That's regulating commerce. And the Supreme Court says, whoa, Justice Roberts writes this. He says, no. By taking someone who is choosing to be outside of commerce, not buy insurance, and forcing him to buy insurance, you're not regulating commerce. You're regulating this guy out here who's outside of commerce. That is not within the commerce power. And so, to his credit, Justice Roberts writes a great opinion on the commerce power part. He says there's no way that this is possible under the Commerce Clause. And most of us watching the case have thought, well, that's great. I mean, if the Supreme Court holds the line on the commerce power, then we win. This is not constitutional. But the Obama Justice Department had another line of argument, and they said, if we lose on that ground, then the alternative is this is just a tax. And you may recall, it was a $700 tax, give or take, that they would impose on you if you didn't buy insurance. And so they said, it's not, even if it's not a regulation, if you don't think this can be a regulation of commerce, then just recognize it as a tax. And that's where Justice Roberts switches and joins the liberal activist judges on the court and says, yeah, it can be a tax. Because the taxing power, and we could do a whole other hour on the taxing power, but here's the tax power. It's right at the beginning of Section 8. Congress shall have the power to lay and collect taxes, duties, imposts, and excises, to pay the debts and provide for the common defense and general welfare of the United States. It doesn't say collect taxes for what purpose. It just says collect taxes. It's pretty open-ended. And there's the taxing clause is a whole nother hole in the cage that has been abused in the past and will probably be used in the future by more liberal, progressive Congresses and presidents. Because the Obamacare decision kind of made it quite clear, hey, just use a tax as your way of enforcing your regulation. Call it a tax, and you're fine. Now the good news here is, of course, the Trump tax cut. Many people did not notice. The Trump tax cut our taxes in multiple respects and ways, but one little provision that was slipped in there by the people who wrote it in Congress, wisely, it eliminated the Obamacare penalty tax. And so now Obamacare is no longer a tax. There's no longer a tax anywhere in Obamacare. And so the one leg that it was standing on is now gone. And so that's why there are follow-up cases making their way to the Supreme Court saying, okay, if the tax is gone, it's not a tax anymore, this thing's got to be gone. So I'm confident that when this case eventually gets there, the Supreme Court's going to eventually recognize that Obamacare can't stand it anymore. There's no tax holding it up. But be that as it may, that still doesn't give John McCain an excuse for voting the wrong way. But I digress. Okay, so we do have a little glimmer of hope that the Supreme Court has tried to put some meaning back into the commerce power and tried to restrict the growth of government and has put meaningful boundaries. But it's a 5-4 issue. We have 5 justices who want to put limits on the commerce power and want to, maintain what started with U.S. v. Lopez and continue the Obamacare decision and just, put some reasonable limits. Because if you don't have limits, let's just back up. If there's no limits on the commerce power, we don't have a government of enumerated powers, right? If you've got a giant exception, your powers are limited except when it comes to regulating commerce, wink, wink. Well, then you no longer have a constitution of enumerated powers. We may as well give up the 10th Amendment and give up the whole game. They could just call everything a regulation of commerce. And so it is so critical, this commerce power. That's why, you might have seen that and said, oh, that looks boring. But the commerce power is really at the heart of the Constitution and the abuse of the Constitution. So things have gone way beyond what the founders wanted. Now, finally, with originalist judges, originalists meaning judges who adhere to the original understanding of the Constitution, finally, we're seeing a little bit of progress. Okay, now let's go to the next section, the Establishment Clause. Very similar story here. The original meaning of the Establishment Clause, and then what happened in the 20th century when the Supreme Court completely changed the Establishment Clause. And the Establishment Clause is really at the center of the culture war that's been going on in this country for more than a decade. So, the original meaning, the wording of the Establishment. It's in the First Amendment, which of course includes the right to peaceably assemble, which we are doing right here. It includes the right to free speech, which I am exercising right now. It includes the right to exercise our religion, which we did with the opening prayer. And it also includes the Establishment Clause. And the Establishment Clause says, Congress shall make no law respecting an establishment of religion. Shall make no law respecting an establishment of religion. Those are odd words. What does that mean? Respecting an establishment. Well, respecting would be observing or regarding establishment of religion, or looking like an establishment of religion. Well, what's an establishment of religion? You have to put it in historical context. The founding fathers were mostly from England, and they were acutely aware of the English history of the late 16th century. And that's when the English Civil War was fought. And the main English Civil War, there were skirmishes all throughout it, but this English Civil War was fought over the question of what would be the established religion of England. Would it be the Catholicism of Mary, or would it be the Protestantism of Elizabeth? And then William and Cromwell come in afterward. They're on the Protestant side, and this conflict consumes England, kills, I don't know what the total death toll, certainly hundreds of thousands of Englishmen. And it's I won't say certainly tens of thousands of Englishmen. It's something that was a defining moment in English history. And the founding fathers of the United States saw that the same sort of diversity of Christian sects was coming into the United States. In fact, of course, many of the early settlers, especially in Massachusetts, were coming for religious freedom. So you had a variety of Catholic states that were heavily Catholic, you had states that were heavily Protestant, you had different forms of Protestantism. And so the founding fathers said, guess what? We're not going to fight a civil war over it. This is just a simple little clause. All we're saying is no official religion of the United States. Okay? Everybody got that? Oh, it's done. That's all it is. No official religion of the United States. We know that in part because several of the colonies and several of the early states, at the time the Constitution was ratified, had official established religions of that state. They were okay with that. The founding fathers evidently thought that was all right. They didn't prohibit that in the Constitution. The Constitution does have a few prohibitions on things states can't do. They didn't prohibit that. So they just didn't want to have a national civil war over what the official religion would be. And to give you some additional insight into this, you should look at one of the writings of one of James Madison's fellow Virginians, one of the unsung heroes of the Constitutional Convention and of the first Congress when they were writing the Bill of Rights, George Mason. George Mason was a great writer, speaker, and influence on the Constitutional Convention. And George Mason had a different proposed wording of the First Amendment Establishment Clause and the other parts. Here's how he would, so the First Amendment includes the Establishment Clause. It also includes the Free Exercise Clause, the free exercise of religion, which we could do a whole hour on that, though we won't tonight. So he said this. George Mason would have worded it this way, and essentially Madison considered his wording just a tighter version of this. Quote, all men have an equal, natural, and unalienable right to the free exercise of religion, according to the dictates of conscience, and that no particular sect or society of Christians ought to be favored or established by law in preference to the others. End quote. Okay, it's assumed that the government is going to be one of, or that the country is one of Christians, and we just don't want any particular sect of Christians to be favored by the government in an established religion. In many ways, this is a more restrictive reading. But in this more restrictive phrasing that Mason would have chosen, they're assuming that the government is going to be a government consisting primarily of Christians, and that certainly the government can do things that might assist Christianity or might in some way endorse Christianity. You're not going to establish an official sect. That's all. And so that gives us some interesting context. And then after the First Amendment was drafted and the entire Bill of Rights were drafted, did you know on the same day that they finished drafting the Bill of Rights, Congress sent a request to President Washington to please call for a national day of prayer and thanksgiving. And so it was the first federal official Thanksgiving declaration to coincide with the issuance of the Bill of Rights. And in the declaration it said, "It is the duty of all nations to acknowledge the providence of Almighty God, to obey His will, to be grateful for His benefits, and to humbly to implore His protection and favor," end quote. So just think about that. On the day that the First Amendment is issued, the same Congress that drafts the First Amendment says, let's give thanks to God and call for the nation to pray, because we're so happy about this First Amendment, which would suggest that the Establishment Clause is not about stopping expressions of God about God in the public square, or stopping government encouragement of religion or endorsement of religion, because they just called for a national day of prayer to thank God for the First Amendment. Then Washington in 1792 would write this, quote, "I am sure that never was a people who had more reason to acknowledge a divine interposition in their affairs than those of the United States, and I should be pained to believe that they had forgotten that agency, which was so often manifest to them during our revolution, or that they failed to consider the omnipotence of that God who is alone able to protect them." George Washington, 1792. And so we have, and there's many, I could quote many of the phrases. Let me give you one more. John Jay, who was not only one of the founding fathers who wrote the Federalist Papers, he was also the first Supreme Court justice. John Jay had this one to say: "Providence has given to our people the choice of their rulers, and it is the duty as well as the privilege and interest of our Christian nation to select and prefer Christians for their rulers." Wow, that's the first Supreme Court Chief Justice of the United States. That history is anathema to the ACLU, which has been intent for the past 70 years to drive all expressions of faith out of the public square. And they use the Establishment Clause to do it. And I give you all of this history. I'm not saying that the Supreme Court today would endorse John Jay's statement, but you have to see the context. The founding fathers were not intending to say that the government cannot endorse or express or acknowledge or promote religion, faith over non-faith, even in that general sense. They were simply talking about stopping a civil war. We're not going to have an official religion of the United States. And again, if we went back in time to 1920, that understanding of the First Amendment would be the understanding that was taught in law school, would be the understanding that everybody had, and there was prayer in public school, and there was no intrusive effort by the government or rather there was no effort by lawyers, bless you, to stop government entities from in any way acknowledging God or acknowledging faith, or do things that might indirectly promote faith or the public expression of faith in God. But that would change under the Warren Court in the 1950s, 60s, well, starting in the 1960s, basically. So let me give you a quick rundown of the decisions. In 1962, in the Engel decision, the court eliminates prayer in public school. 1963, in the Schempp decision, the court eliminates the reading of the Bible in public school. Rules that that's unconstitutional, I should say. In the Graham decision in 1980, the court says you can't post the Ten Commandments in a public school. Never mind that they're posted on buildings all over Washington. You can't post them in public school. 1985, in the Jaffrey case, the court says you can't have a moment of silence in public school. In 1992, Lee versus Weissman, you cannot have, it's unconstitutional to have a prayer at a graduation ceremony. Then in 2000, Supreme Court rules in a case coming out of Texas that you can't have a student-led prayer at a football game. Even if the student writes the prayer, no teacher had anything to do with it, no member of the faculty, no school official had anything to do with it. This is a student-written and read prayer at a football game. They can say whatever they want. They could give an atheist message if they want. It was just, they pick a student to come say a message, which is some sort of prayer or invocation to solemnize the football game. And the Supreme Court says you can't even do that. That's an indirect endorsement of religion because you're using the school's microphone, the school's speakers, to broadcast the message. Of course, this misses the point because in Texas, football is a religion anyway. So there's no way to avoid it. But anyway, I digress. So in 2005, it gets even crazier. Well, no, it's not crazier than that. But in 2005, it gets even more confusing. the Supreme Court issues 2 cases on the exact same day. And one case says, and they both concern the Ten Commandments. One case says, it's coming out of Texas, it is okay, for the first, oh, this is a surprise, it is okay to put the Ten Commandments on a monument, a stone monument on the grounds of the Texas Capitol. However, it is not okay to put the Ten Commandments on a plaque on the wall of a Kentucky courthouse. What? This is the same justices on the same day. It's not okay on the wall of the courthouse, it is okay on a monument on the Texas Capitol grounds. Why? Explain that one. 2 words, Justice Breyer. Justice Breyer was the swing vote, and he joined the 4, so the other 8 justices were consistent. The originalists were saying it's okay in both places, and the liberal activists were saying it's not okay in both places. Justice Breyer joins the majority, and he joins the conservatives on the Texas case, and he joins the activists in the Kentucky case. And Justice Breyer explains himself in his opinion in each one. He says it's all a matter of context. And you have to look at the surroundings and the context to see if it really is an official endorsement of religion. And he says, if you look at the Texas Capitol grounds, there are other monuments, there are statues of people. It doesn't really look to him like an endorsement of religion. But if you look at the Kentucky courthouse, it's on the wall in a courthouse. And that somehow makes it more official. And he says, as a matter of context, that one looks like an endorsement of religion to him. The other 10 Commandments is not an endorsement of religion. It was absurd. And so basically the Establishment Clause now depends on which side of the bed Justice Breyer gets up on in the morning. It's almost that absurd. And now fast forward to last year. 2019, how many of you heard about the Bladensburg Cross? Does that sound familiar to anyone? Okay, so the Bladensburg Cross case is one that it was called American Legion versus American Humanist Association, which is an atheist group. And they brought a First Amendment challenge to this 32-foot high stone cross statue, not with Christ hanging from it, but just a cross, sort of an abstract cross. And it was a monument to those built in 1925 to those who died in the First World War. And it was built, it was paid for by the American Legion with private money, and it was placed next to a highway. And it was originally placed on private ground, but eventually the state, through eminent domain, acquired the ground, and where it was now on the median of the highway. So you had lanes going this way.
It's in a roundabout.
It might be in a roundabout. No, it's in the median.
I grew up in Bladensburg.
Okay. Point is, it's in the grass between the lanes. Okay. Yeah. And at one time that was along one side of the highway. They subsequently put lanes on both sides of it and took over this private ground. So you've got this cross, and the atheists are saying, hey, that's on public ground, public highway. Looks to us like the state of Maryland is embracing Christianity. You can't do that. That's a government endorsement of religion. And the American Legion is saying, no. This is to commemorate the war dead, and this shows how far we've got from the original understanding. To defend an expression of religion, most attorneys have to go to, well, it's not just about religion. Yes, a cross is the symbol of Christianity, but it is also a commemoration of those who gave their lives in the war and their sacrifice. We use crosses to represent and respect the sacrifice of those who died in battle. So yes, it is, but it's also this, and any effect it might have in promoting religion is incidental, it's indirect. And so the Supreme Court, to their credit, votes with the American Legion and allows the cross to stand. But it was a 7-2 vote, and the 2 justices, among the 7 were Gorsuch and Kavanaugh. Thank you. It's been a long day. Gorsuch and Kavanaugh. And if Hillary Clinton had won the election and Gorsuch and Kavanaugh had not taken those 2 empty seats, and it had been Judge Garland who had been appointed, who had been nominated by Obama, if he'd gotten that one and someone similar had gotten the other seat, then it would have been 4-4 again, and Justice Breyer would have to decide. Now, Justice Breyer probably, got up on the right side of the bed that day, or maybe just saw that it was 6-3 without, or 6-2 without him, and he goes to the majority. But if it were 4-4, I'm pretty sure Justice Breyer would have had a really tough time deciding, and I suspect that Justice Breyer might have voted with the activists. And if he had, then either the cross would have been torn down, or the alternative remedy suggested by the American Humanist Association was, you don't have to tear it down, you can just take off the two horizontal parts of the cross and just leave the vertical part, and it'd look like the Washington Monument, and that'd be okay. We're okay with that.
An obelisk.
Yeah, and make it an obelisk. Yeah, that's exactly what they said. We're okay with you ripping the arms off the cross. How absurd. And in writing a great opinion for the court, Justice Alito writes the opinion. He says two things that are important to understand. He says, even if the original purpose of a monument was infused with religion, the passage of time may obscure that sentiment. Okay, true. But even so, I would argue, if you're looking at the original understanding of the Founding Fathers, that's okay if it's infused with religion. But Justice Alito made these points, which I think are especially poignant. A government that roams the land, tearing down monuments with religious symbolism and scrubbing away any reference to the divine, will strike many as aggressively hostile to religion, end quote. Because remember, if you take this expansive view of the Establishment Clause that the activists want, they say the government can't either endorse religion or non-religion. And if the government's running around ripping down monuments, that looks like an endorsement of atheism. And so, anyway, that's thank God that was the decision of the court, and the cross stands. But if Hillary Clinton had been elected, it is quite likely that the case would have gone the other way. And right after that cross was ripped down, you would see state governments and city governments all across the land taking down crosses, because the ACLU writes them a nasty gram saying, guess what, after the Bladensburg case, you gotta take down that cross. And most cities and states and counties just, when they get a nasty letter from the ACLU, they just fold up their tent and go away and do whatever the ACLU wants. So we came this close, and the only thing that made the difference was the election of Donald Trump and the successful nomination and confirmation of Kavanaugh and Gorsuch. These elections have consequences. There's a reason why members of the Senate Judiciary Committee fight like cats and dogs over Supreme Court judicial nominations. People realize that it is all down to one vote right now. And big questions, whether it's the Commerce Power or the Establishment Clause, are at stake. So the recent cases have, including this cross case, and including the rational decision of Justice Breyer in the Ten Commandments case. The recent cases have said, yeah, you can, we're starting to recognize, we're turning the ship around, and we're at least recognizing that it's gone too far with this notion that anything that looks like a potential endorsement of religion by somebody, that doesn't necessarily mean that it violates the Establishment Clause.
How about Gonzalez? Is that going to affect it?
Which,
Gonzalez v. Montana, the Lane Amendment case?
Remind me, which one does that say
Well, it's
there?
the one where they allowed tax exemptions for contributions to basically private schools.
Oh, yeah, so that one, there have been a number of private school cases that have gone up and have been challenged on First Amendment grounds. And there's several that the Supreme Court has already ruled on. And the Supreme Court's general way of looking at it is, as long as there's an element of choice, as long as the federal government, or state, in this case the state government, isn't giving money to a church or giving money to a Christian organization, but is instead giving the subsidy to a parent, and then the parent can decide where to put it. The view of the originalists, the conservative justices, has been, then the government is not preferring religion, even under these aggressive notions of the Establishment Clause, and therefore it's okay. So I anticipate that that's probably, they'll continue to hold that doctrine. That's another area where the court has taken a line that's, again, closer. It's swinging, the pendulum's hopefully swinging back. But we've only got 5 justices pushing in the right direction. The other 4 are pushing it aggressively in the direction against the meaning of the Founding Fathers. Okay, cruising along here. We're about an hour in. All right, I'll try to wrap this up and then we'll take questions, all right? Okay, last area is the Second Amendment. This is an area just like the others, where you have the original understanding of the Constitution, and then you have something that is completely different. So, by the way, some of you heard me, I've given some speeches to gun groups, and I like people to understand this in Kansas, because we should be proud of our state. We have a wonderful state. I think we have the best state in the union. And there's one thing that we are number 1 at, in addition to having, technically the Chiefs are on the Missouri side, in addition to having the number 1 football team, we do have the number 1 position in this. We are the state whose people are most supportive of the right to keep and bear arms. Well, that's a nice claim. Kris, how can you make such a claim? I can make and prove that claim to you because most state constitutions have a state right to keep and bear arms that roughly mirrors the Second Amendment. And in every state but Delaware, a state constitutional amendment has to be approved by a vote of the people after the legislature passes it. And so we have all kinds of evidence of how big a vote the state, and I'm not aware of a single one that has voted down the right to keep and bear arms, even in liberal states. But in Kansas, in the year 2010, I expect everyone who was old enough in this room voted on that constitutional amendment in Kansas. And that amendment said a person has the right to keep and bear arms for the defense of self, family, home, and state, for lawful hunting and recreational use, and for any other lawful purpose, end quote. A record 88.2% of Kansans voted in favor. 88.2. That blows away the competition. Second place goes to West Virginia in 1986 when 83.4% voted in favor of their right to keep and bear arms. So I rest my case. We are the #1 state in America in the right to keep and bear arms. Hooray for Kansas! So that's a good thing. It shows that our culture of support for lawful gun ownership and our understanding that this is important to our nation is strong here in Kansas, and we should be proud of that. I'm proud of that. Okay, and as many of you also know, not only did I teach the Second Amendment, I practice the Second Amendment. I'm an avid hunter and shooter and enthusiast in the whatever shooting. It's fun, and of course I, like many of you, I protect myself and my family with firearms as well. And so this is a really important one to me, and this is one I take a lot of interest in, and I think most of you do too. So the Second Amendment, it's one of the shortest amendments in the Constitution. It says, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed.
Period.
Period. And stop. Shall not be infringed. Shall not be infringed. Shall not be infringed any bit. It's it. You can't infringe it. You can't shrink it. You can't cut it away. You can't push it. Well, that amendment could not be tested in court. The first century of the country, it was rough. It was obliquely touched on in the 1870s, but they didn't really get to the meaning of the case in the Supreme Court decision then. And for the first 150 years of our country's existence, it really didn't come into play much, because the Bill of Rights itself didn't apply against state governments until the 14th Amendment. And then after the 14th Amendment is ratified in the late 1860s, there really aren't that many challenges to either state or federal restrictions. But then finally, in the 1930s, we come up with the Coleman versus Miller, U.S. versus Miller case. And in 1939, the case went like this. So these two guys traveled to Arkansas, and they did so without purchasing the required federal stamp you had to transport a sawed-off shotgun across a state line. The federal government had started regulating this, and this was, of course, these federal regulations of firearms. As many of you know, these national firearms laws started in that period, and it was, the mob era and all that. And the Supreme Court, and they challenge it. They say, you can't do this. You're infringing our right to keep and bear arms. You can't say I can't carry this firearm across a state line. And the Supreme Court rules against the firearms owners. And rules against the firearms owners by saying you're not covered by the Second Amendment. You two people don't have a Second Amendment right concerning that sawed-off shotgun. What? The reasoning of the Supreme Court in the Miller case is you don't have a right to protect that shotgun because the shotgun is not a weapon of war. No, they had no knowledge of the future when nowadays a shotgun is a weapon of war, and of course the U.S. military uses it frequently in urban combat settings in the Middle East and whatnot. But that's what their ruling was. Now, of course, that's a bizarre ruling too, by the way. That means the Second Amendment only protects weapons of war, which would be ARs, bazookas, nuclear missiles, I don't know, cannons. I mean, the Second Amendment, but the way and then the liberal lawyers got a hold of this and they said, oh, yeah, that's right. Okay, the only way we can make sense of this, and the only way the Miller court, it's a convoluted opinion that the court wrote in 1939, but basically The Miller Court was looking at those first words, a well-regulated militia being necessary to the security of a free state. And the Supreme Court was saying, and these liberal lawyers latched onto it, started proclaiming it, and teaching it in law schools, the Second Amendment can only be exercised by a militia. Well, what's a militia? A militia, they said, is the National Guard. And the Second Amendment only applies to members of the National Guard when they're in uniform acting as members of the National Guard. And it only applies to military weapons. What? And this thus was born the collective rights theory, that the Second Amendment is a collective right. All of the other amendments in the Bill of Rights are individual rights. You have that individually. It is your right, and you can exercise it. But the Second Amendment, you only get to exercise when you're wearing a uniform and you're a member of a collective group called the National Guard. Nonsense. But that was the view that the liberal left was pushing, and that's the view that was being taught in law schools. Oh, it's a different kind of right. You individuals can't use the Second Amendment. That's only, and isn't that perfect for the left, right? You make the Second Amendment a strange right that individuals can't exercise. Until in 2008, in the Heller decision, District of Columbia versus Heller, one of the greatest decisions, I would say it might be the greatest decision Justice Scalia ever wrote. And if you have never read a Supreme Court decision in your life before, read District of Columbia versus Heller. It's a really, really interesting read. The case was a challenge to the District of Columbia ban on handguns. And Heller actually worked as a guard at a federal building. And so he was using a handgun on the job, but he was prohibited from taking a handgun home, even his own private handgun, and protecting himself in his home. And he challenged it. Case goes all the way to the Supreme Court. And by a 5-4 decision, the Supreme Court, thank God, rules that the First Amendment, or the Second Amendment, is an individual right, and it does protect your right to have a handgun in your home for self-defense. Okay, how did Justice Scalia get out of Coleman versus Miller? Well, basically he completely rejected, not Coleman versus Miller, United States versus Miller. How did he get out of that reasoning and come to the conclusion? He said, in perfect Scalia form, you have to look at the meaning of words. Scalia, he had his two doctrines that he brought to prominence in America were textualism. Words mean what the words mean, and you have to find out what the legislature meant or what the founding fathers meant when they used that word. And originalism. The only coherent way to understand our Constitution is to say, what did the framers mean? And what did the ratifiers mean when they wrote those words and ratified those words? You don't understand, you don't take these words and have a liberal lawyer or a liberal judge in 2020 say, I think militia means this. No, you have to look at what militia meant to the founding fathers. And Scalia does this much better than I can, but basically here's what he says. Look at the words. A well-regulated militia being necessary to the security of a free state. What does that mean? First, you have to define militia. What did the word militia mean in 1789? Militia meant the body of free people called to arms. That was the clear, established, universally recognized meaning of militia. The militia is all of us called to arms. When the governor calls us to arms, we are the militia. That's what it means. And that's what everybody understood it to mean at the time. So a body of free people called to arms, the militia. The militia, you didn't have to have a special badge or a special uniform. In fact, most of them didn't have any uniforms. You just were an able-bodied free person. If you were called to arms, you were a member. If you're called, you instantly become a member of the militia. So all people are the militia. Okay, well, what about this well-regulated part? A well-regulated militia. So when we, in the year 2020, hear the word regulated, we think of regulations. We think of rules. We think of the government telling us what to do. Something that is regulated has lots of rules and lots of restrictions on what you can do. That is not what regulated meant in 1789. They did not use the word that way. Think of the phrase regulars versus irregulars. Remember the irregulars of the Swamp Fox, Francis Marion, fighting against the British regulars in their red coats? Regulars were trained troops. Irregulars were untrained, unofficial troops. Regulation meant training. If you were regulated, you were trained. So the irregulars are the untrained, the farmers called to arms. The regulars were professional soldiers who are trained. And so now it starts to make sense. So let's put in let's substitute in here the actual meaning of the words in modern 2020 phrases. So instead of a well-regulated militia, a well-trained body of free people called to arms, being necessary to the security of a free state. Oh, now I understand. A free state is one that does not depend on a standing army. A free state doesn't need to have a giant state, and this was part of a debate at the time. And they were trying not to be disrespectful of Washington. They were appreciative of his being commander of what was a standing army. But they said, we don't need a standing army. A free state is protected by the body of people called to arms. So here we go. A well-trained body of people called to arms being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Oh, I get it. How are we going to be well-trained if we don't have guns? You have to have guns in order to practice shooting. That is what it was saying. And if you look at the writings of the Founding Fathers at the time, especially in Congress, because it was the first Congress that drafted this, if you look at Noah Webster, he says that he talks about the history of the world, and he says, in order for a people to be overcome by a tyrant, they must first be disarmed. And British history, similarly, had several episodes where the crown disarmed the people. And disarming the peoples was what you did to subdue the people. So a free people means a people that will not be subdued by their government because they are armed. And a free people will be a freer society will be one that does not depend upon a standing army, doesn't necessarily need a standing army to defend itself. Now things have changed, and obviously the United States has a standing army right now. But the point of the Second Amendment was to say, no, the people have the right to individually own these arms because an armed people is a free people, and a secure free people will allow the people to practice shooting. That's what that phrase means. And Scalia explains it better than I just did. But that's the essence of freedom in America, right? You think about the liberals, they dismissed the Second Amendment. The people I went to law school with at Yale just were like, most of them were, no, nobody owns guns. People don't need guns. We have the police to protect us. We have the army to protect us against invasion. We really don't need guns anymore in today's society. And there's so much of this country that just thinks firearms ownership is something for weird people like me who wear camo. But they don't understand that firearms are more than just something you use to hunt, more than something you use for, if you like, target practice and shooting competitions. Firearms are about being a free people. And this Second Amendment right is a foundation on which many of the other rights stand. If you don't have a free people that has a sense of sovereignty over itself, and where the people are sovereign over the country, then all of the other freedoms start to erode. You think about this. If the government doesn't trust you to have firearms, then the government has a monopoly on firearms. The government is saying, you aren't fully capable of being free because you people just aren't responsible enough to own firearms. I mean, it's almost if you don't have a government, a system that trusts the people to hold arms and gives a monopoly on deadly force to the government, it's kind of a distrust of the people. It's saying that people are not fully competent to exercise freedom. This freedom is too dangerous. You people are irresponsible. That's what the anti-Second Amendment view has. So the Second Amendment is really a cry of freedom. It is saying we believe that the people of this country are the rulers of this country. And as the holders of all authority and sovereignty in this country, the people can have deadly force, can possess firearms. It's not something that you just give to the government. The people themselves are permitted to have this. And that's why it sets the United States apart from so many countries. There are other countries that allow the people to keep and bear arms. But this is at the very bedrock of American freedom. And so let me just wrap it up with this. The Supreme Court in Heller sets to rest the collective rights theory, sets to rest the notion that it's not an individually held right, and is an eminently reasonable and historically accurate opinion. But it only had 5 justices voting in favor. The other 4 justices were all in favor of saying, no, you don't have a right to defend your home with a handgun. And for that matter, they would have held the same view about a long gun. That's extraordinary. Our Second Amendment freedoms are one heartbeat away from being lost. If one of the Democrats, all of whom have a very liberal view of the Constitution, and they don't see the original meaning of the Constitution as relevant. If one of them wins the presidency and appoints an activist justice, and there is a vacancy on the court, and God forbid one of the originalist justices dies or retires, then that would change the meaning of the Second Amendment. They would change the meaning of the Second Amendment. The next case would come up. They would overturn Heller, most likely, and they would say, no, the Second Amendment has limitations. I don't know how they frame it. They probably wouldn't go all the way back to the nonsense of Miller, but they would say you don't have an individual right to keep and bear arms. We are one heartbeat away on this. And the same thing with the Establishment Clause. We are one justice away. Same thing with the Commerce Power. We are one justice away from going the wrong direction again. And so in each of these cases, each of these stories, you have the original meaning, you have the Supreme Court careening away from the original meaning during the 20th century, and only now, in the last few years, have originalists on the court, all of them appointed by Republicans, by the way, which is the only party right now that's serious about the original understanding of the Constitution, which was why I felt like vomiting so much during the impeachment hearings, when people like Nancy Pelosi would pay homage to the Founding Fathers and say, the Founding Fathers clearly intended that this kind of conduct should not happen in the executive branch, as if they care. They don't look to the understanding of the Founding Fathers whenever it doesn't suit them. Whereas we, on the original side, say, yeah, well, we're going to look to what the words meant to the people who ratified the Constitution and wrote those words, and that's how the decision goes. That is the only coherent way to interpret the Constitution. And we are still not out of the woods yet, because it's 5-4 on all of these cases. And if we did the extended dance version of this class, we would be talking about the religious free exercise clauses, we'd be talking about Roe v. Wade and the abortion cases, and we'd talk about the taxing power, and we'd talk about the 10th Amendment. But it's the same story. I could write another 4 chapters here to give you another 4 chapters. In every one of those stories, there was the original meaning of the Constitution, which held sway for at least a century. Then in the 20th century, liberal justices changed the meaning of the words, just twisted the meaning of the words, and then in the abortion case, invented words that weren't there. And then only in recent years has there been a turning back toward the original meaning. But we're still a long way. We're just turning back toward it. It's still way over here. So that is your quick summary of the history of the Constitution of the United States.